Kevin Rundlett with Rundlett Law Firm. We've been helping injured Mississippians for over 20 years. We're putting out these videos just to provide some information to people who may have been injured on the job or injured in the state of Mississippi, just to provide answers to questions that we get all the time. Today we're going to be talking about, can I sue my employer outside of the workers' comp case for a big negligence case, for big money? The short answer to that is no. Well, why is that? Years ago, the Mississippi legislature, just like many other states throughout the country, instituted the law of workers' comp. There are reasons for instituting that law. First of all, if someone was injured on the job before workers' comp was in place, for them to get any relief, they would have to go through the civil system of the law, which can take many years without any relief. If they file suit today, they may not see any relief for years down the road until the case was litigated. It just takes a long time. And obviously this causes problems to someone who's hurt and may not have any other insurance, can't get to work, has a family to support. So the workers' comp law was devised so that quick relief could come to someone who is injured on the job. So they have some money coming in to pay some bills so that they can help support their family and so that they can get medical benefits really quickly to try to get better and get back to work. That is really the goal of the workers' comp law. On the flip side of that, you do not have to, as an injured worker, prove that your employer was negligent. You don't have to prove that you did or didn't do anything wrong. If you were injured at work, it is probably a compensable claim, meaning it falls within the workers' comp law. The law says that workers' comp for an injury that happens on the job is the exclusive remedy. You can look this up easily, do a Google search on section 7139 of the Mississippi Code, and you'll see exactly what I'm talking about. It's very clear that the exclusive remedy is workers' comp if you're injured on the job. So there is an exception to that too. You can sue your employer if they were supposed to have workers' comp coverage, but they didn't. So they don't have that insurance policy to fall back on. Generally, it is if the employer, the requirement is if the employer had 5 or more employees, then they're supposed to have a policy of workers' comp coverage to protect their workers. And if they didn't, there is a way to sue them in civil court. It still may take a while. There's not going to be that instant relief with injuries, but you can do it. There's another instance where a suit can be filed that is related to your workers' comp injury, and we call that a third-party injury. The best example I can give you is, let's say you're a traveling salesperson and you're driving from point A to point B for work, and someone else comes out of the blue and T-bones your car and causes injuries and an accident. You were working, but it wasn't your employer that caused this. It was a third party. There is a way to go after that third party while a workers' comp case is pending. So really you can have both benefits. I hope this video is helpful. If it is, hit subscribe and we'll send you new content as it comes out. Thank you for watching.